Good morning. Welcome to this webinar from Hunt & Hunt North Ryde office this morning. This session is going to be about protecting assets, family law, family provision and under wills and how it all works. I'm the presenter and I suppose the compere today, and my name is Catherine Keeley. I have two of my colleagues here who will introduce themselves shortly, Anthea Tronson and Tim Story. I'm a partner and an accredited family law specialist, so I'm going to talk to you about, in summary form, how the law operates about property settlement, what are the key aspects to note in family law, what's disclosure, can you quarantine out any assets, and some key points. And then the others will talk to you about their respective topics. We'll also take questions at the end. So if you'd like to ask any questions, you'll see at the bottom of your screen a Q&A function. And so if you can pop your questions in there a little bit later on, we can come to those questions. I can't guarantee we'll get to all of them, but we'll do our best to cover those that we can in the allocated time frame. So I'd now like to introduce you to my colleagues who are here today. And so Anthea, would you like to tell our attendees a little bit about you?
Hi, I'm Anthea Tronson. I've worked as a solicitor at Hunt & Hunt for 19 years and I practice in the area of will disputes.
Thanks, Anthea. And Tim, would you like to tell our participants a little bit about you and your practice?
Sure, I'm Tim Story. I'm a special counsel at our North Ryde office here. I mainly practice in the areas of property law, wills and estate planning, and general commercial law. And I'll be talking today trying to tie in some of these topics that Catherine and Anthea are talking about and how they affect your wills and estate planning.
Thanks, Tim. Okay, now I'm going to share my screen in just a moment, and many of you will be familiar with that, having been through months and months of Zoom. And I'm going to take you to some slides and talk to those slides. So I'll just do that now. There's a slide that just introduces us and has some details about us. But let's go to my segment, which is how are family law property settlement cases sorted. We often hear stories in the media, and we've just heard recently that the Gates have split up after a long marriage. But what's the law in Australia? It's quite different to overseas countries. We have the Family Law Act here. It's been around since 1975, but it's been amended many times. And in its present form, the law applies to everybody. So people who have been married and who are no longer married, whether they're separated or they're divorced. It applies to de facto couples and also to same-sex couples. And our focus today is not on some parts of the Family Law Act that relate to children. We're going to look at assets. And when I talk about assets, I'm talking about all different types of property. So real estate, motor vehicles, shares, monies that are sitting in bank accounts and so forth. I'm going to look at how a lawyer advises clients about family law settlements, so financial settlements or property division or asset division. And just in essence, the way the law works is that it's set out in the Family Law Act, but a number of cases have established an approach that's taken by the courts in trying to resolve family law financial settlements. So the laws set out for married couples in sections 79(4) and 75(2) of the Family Law Act, and some slightly different sections for de facto couples, including same-sex couples. And the sections that apply to them are section 90SM and 90SF subsection 3. What do all of those mean? In summary form, what the court does is it looks at the contributions that the parties have made, and I'll come to the four-step approach in a moment. And the court would look at not just the financial contribution, but non-financial contribution and the contribution as homemaker parent. And the way this is done, and many cases before the court have established this as authority, and this is the method too that's used by people when they negotiate and even in mediations, is the first thing you have to do is know what you're talking about. So what are the assets and liabilities of the parties? So assets includes all types of property. Liabilities would include such things as mortgages, loans, credit card debts, debts to the Australian Tax Office. And financial resources need to be identified. Financial resources can include things such as interests in a family trust where your client or you are a beneficiary. It could also include an interest in an estate where that estate hasn't yet been distributed. So identify the assets and liabilities is step one. Step two is when we go back into history and look at the contribution of the parties to the acquisition, that is buying or purchasing property, conservation, that's maintaining property. So, you know, be it paying monies or physical effort to maintaining property, and improving property. Improvement, of course, is renovation and refurbishment. So it's not just financial contributions, it also covers non-financial contributions. There's also a requirement under the legislation that you look at the contributions of people as homemaker, that, you know, whether or not they've got children, and if they've got children, contributions as parent. So it's not just financial contributions. The third step that's taken in this four-step approach is to look at, for example, the parties' comparative needs. And that is how old they are. Are they in good health? Has the length of the marriage, for example, adversely affected their earning capacity? Those sorts of things are taken into account. In fact, there's a whole list of items set out in that section 75(2) of the Family Law Act, and we go through each of those items. And finally, the court looks at, and we look at whether or not the division that's proposed would be just and equitable, that is fair in the circumstances. So that's the approach that's taken. And interestingly, it's not moving. Oh, sorry about that. I'm just trying to move the slide on. A question that comes up for many people is, you know, do we have to split things 50-50? I'll tell you what the law says, and I'll tell you what happens in practice. There's no presumption in the Family Law Act about equal contribution to assets. So there's no presumption. And there's no starting point at the end of it of a 50-50 division. But what happens is, in long relationships, and I'll come to what is a long relationship in a moment, it's often that a 50-50 split is just and equitable. And that's whether or not you've had both parties working throughout the relationship and applying the monies that they receive by way of income to acquiring assets, or whether or not one party has been in the workforce and the other party has done the majority of the work that is done raising a family and running the home. So people often will agree on a 50-50 split. And just be aware though that the court will not always do a 50-50 split, and there's very different cases about. It really depends upon the circumstances of the case. I've flagged here what's a long relationship. So obviously 30 years and 20 years is a long relationship, but these days it's seen that 10 years can amount to a long relationship. So the most important thing to realise is that every case will turn on its own facts, and I'll come to that a little bit later on. One of the key principles in family law, and this is something that surprises some people, is that there's a requirement that both of the parties, both of the partners to the relationship, have to make full and frank disclosure of their finances. And that's an ongoing obligation. So they do it up front, and they must do it if things change during the course of the negotiations or during the course of court proceedings. And there's a duty of disclosure. It's set out in the legislation and in the court rules that parties have to fully and frankly disclose everything. That is their assets, their liabilities, their income, their expenses, and their financial resources. somebody who is involved in family law negotiations or in family law proceedings can't simply decide to leave it out because the other side doesn't know about it, or put it into another bank account, to give it to somebody, to ship an asset offshore or something like that. You're not allowed to do that. And I'll tell you the the consequences of doing that shortly. The court has heavy sanctions which they can impose if somebody doesn't disclose. And in fact, if you have orders made by the court, be they by consent, that is by agreement, or after a hearing, and it's found that you don't disclose, then the court's got power to set aside those orders. So what happens if you don't disclose fully your assets, your liabilities, your income, your expenses and financial resources? There's been a number of cases that have gone to the full court of the family court, but one of my favourites is an oldie but a goodie called the case of Black and Kellner, which is back in the 90s. In that particular case, the husband was a chiropractor who ran his own business, but it transpired that he actually ran two sets of accounts, two sets of books for the business. One in which he recorded credit card payments and payments back then made by cheque, and the other one in which he recorded cash payments. What he wasn't doing was disclosing to the tax office the receipts that he received by way of cash. And at trial, the trial judge gave the husband about 6% of the asset pool because the trial judge found that the husband hadn't been full and frank and was caught in, and the quotes there, what amounted to little more than a blatant lie in relation to the record of his income. And so the full court went on appeal to the full court. The husband appealed it. He didn't like getting 6% of the asset pool, but he wasn't successful on appeal. And the judge said that, had there been a cross appeal, that is, had the wife put on a cross appeal, that one of the judges of the full court may well have given the husband nothing. So what happened? He got about 6% of the asset pool because he hadn't been full and frank, because he'd chosen not to tell the truth about what his income and assets were. There's other cases like that. So there's a message from that case, and that is you have to play by the rules. So what processes apply to make sure disclosure happens? Well, negotiations usually start by the party, with the help of their lawyer, completing a detailed financial statement as well as a detailed balance sheet. And that financial statement is also required if you end up filing proceedings in the court. There's also quite detailed pre-action procedures that are set out in the family law rules, which require the parties to give each other a whole lot of financial documents for the last 3 financial years ended, including income tax returns, notices of assessment, superannuation statements, financial statements for companies and trusts which the parties have an interest. So quite a lot of documents have to be compiled, and that's all part of pre-action procedure. And in fact, it's the lawyer's job, together often with accountants, to review those financial statements and the pre-action procedure documents to actually to ascertain what's there to divide, what the assets are, and if there's any issues about value. And it's only at that stage, once these documents have been exchanged and you've got the financial information, that you can advise about likely outcomes. A question that often comes up, can you quarantine out any assets? The short answer is no. We're not in America. Some states you can do it. All the assets have to be disclosed. Even if a party had the asset before cohabitation, before they started living together, or they acquire the asset after separation. There's various submissions you can make about that to court or also in negotiation, but you still have to disclose. Sometimes it is possible, if you're doing planning at the beginning of the relationship, to try to stop the other party, the spouse, contributing to an asset. And we can give you some advice about that. But basically, it involves not mixing various monies and ensuring that the one particular party is the one who is the director, shareholder, and so forth. It's quite complex and beyond today, but we can certainly give you advice about that. So the key points are, every case is determined on its own facts. So what happened in that relationship every relationship's different. So please don't rely upon what happened in a friend or a colleague or a relative's family law case or what you read in the press. And be really cautious about Googling cases and thinking that case is just like yours. It's always best to get advice from a lawyer and get advice early, and get advice in family law from somebody who is an accredited family law specialist, as opposed to somebody who doesn't work in the area, because they're able to tell you about the way the system works, to guide you with practical and legal advice, and importantly, to tell you about the options that are out there. And there's a number of options, and just in summary, they are at the bottom of the screen here: negotiation, with lawyers assisting or direct between the parties, mediation, arbitration, collaborative practice, and litigation. We can talk more about those in another webinar in the future. So that's, I think, the end of my presentation. So I'd like to turn over now to Anthea. Thank you.
Okay, thanks for that, Catherine. I will be talking about issues associated with challenging a will. There are two ways to challenge a will. One is to challenge the validity of the will document itself and say that that document is not valid. And the second is through what's known as a family provision claim. Today, we're going to take a look at family provision claims, and in particular, look at who is a person who is eligible to make a family provision claim. Family provision applications are made where there is agreement that the will is valid, but someone feels that they were not left enough. It is important to note, someone cannot prevent a claim on their estate, but one can be made aware of who can claim and why. So who can challenge a will? The first step that must be taken to obtain an order for provision is to show that one is an eligible person. Secondly, one must show that adequate provision was not provided, but as I said earlier today, we're only going to be looking at that first step, who is eligible. To make a claim, one must have a connection with the deceased. The Act sets out categories of eligible persons. As you can see on your screen, the first is spouses, which is fairly self-explanatory. The next is former spouses, which is interesting and sometimes surprises people. The former spouse of an applicant is also eligible, but they must prove that there are factors warranting the making of an order. The factors warranting an order for provision being made can include the fact that there was no property settlement at the time of the divorce or afterwards, or that a former wife or husband brought up the children of the marriage without child support from the deceased. Where there has been a property settlement, it is unlikely that there will be factors warranting making an order for provision in favour of a former spouse, but it's not impossible. De facto spouses are another category of eligible persons. We're going to come back and have a bit more of a detailed look at de facto spouses because it's very interesting law. The de facto definition changes from family law to estate law and even within the estate areas. And there is a different test when proving whether a de facto relationship existed for persons of family provision as opposed to intestacy, which is when a person dies without a will. Children are also eligible persons, and a child of the deceased of any age may make an application. A child includes an adopted child or a child born out of wedlock or a child arising out of a domestic relationship. Stepchildren or foster children are not included in the definition of a child and consequently are not automatically eligible, but they may come under a different category below. Grandchildren, nephews and nieces or parents are not eligible categories per se, but they may come under the following category, which is a member of the deceased's household. This area is growing due to mixed families and shifting domestic arrangements and relationships. Hence, grandchildren who may have lived with the deceased at some time as part of the deceased household may become eligible, even if they were not partly or wholly dependent on the deceased. This same test could apply to nephews and nieces, stepchildren, and former de facto spouses, and even parents. The precondition is that the applicant must have been partly or wholly dependent on the deceased. The applicant need not have been a member of the deceased's own household, only that the applicant was a member of a household of which the deceased was also a member. Also, the applicant need not have been dependent on the deceased either at the time of the deceased's death or at the time of being a member of the common household, although the latter is more usual. All that is required is that dependency at any time occurred. The last category is a person living in a close personal relationship with the deceased. And this is to be the case at the time of the deceased's death. Usually this is a person such as a carer who has been living with the deceased and caring for him or her for a considerable time for no reward. In modern relationships, the application of the definitions of household and dependent can have problems. Now turning to the definition of the term de facto. A person is eligible to make an application for provision if at the time of the deceased's death, he or she was living in a de facto relationship. Section 21C of the Interpretation Act lists the meaning of de facto partner. The meaning of de facto relationship is if two persons, A, have a relationship living as a couple together, and B, they are not married to one another or related by family. I think it's a really interesting point to note the Act specifically says a de facto relationship can exist even if one of the persons is legally married to someone else or in a registered relationship or interstate registered relationship with someone else. In determining whether two persons have a relationship as a couple, all the circumstances are to be taken into account, and a few matters have been listed as relevant to this question. And they're listed on your screen there. You can see the duration of the relationship, the nature and extent of their common residence, whether a sexual relationship exists, the degree of financial dependence or interdependence, and any arrangements for financial support between them, the ownership, use and acquisition of property, the degree of mutual commitment to a shared life, the care and support of children, the performance of household duties, the reputation and public aspects of the relationship. No particular finding in relation to any of those matters is necessary in determining whether two persons have a relationship as a couple. Rather, all of the factors are considered as a whole. There are limitations to section 21C, as identified by His Honour Justice Hallen, who observed that the matters listed in 21C do not describe the essence of a de facto relationship to be found in the phrase as a couple. Hallen is known to have said, thus, once the physical or factual relationship has been examined, whether a mental ingredient also existed should be considered. That ingredient involves some commitment by each of the parties to their relationship. It need not necessarily be a commitment intended to last forever or indefinitely, nor need it be a commitment to a long-term relationship, but it should at least be a mutual commitment for the foreseeable future. Justice Hallen is cautioning against a too mechanical application of the matters referred to in section 21C. The essential ingredient to living together as a couple is the intention to commit to a common life. There are types of relationships which do not amount to a de facto relationship, such as friendships, courtships, and people who have shared accommodation. The fact that sometimes these types of relationships involve the provision of financial or other assistance, such as accommodation, do not make them de facto relationships in the absence of a merging of lives so that there is a mutual commitment to a shared life. In determining the existence of a de facto relationship, the totality of the relationship must be examined, including its changing nature over time. Bouts of selfishness or infidelity are not necessarily inconsistent with the existence of a de facto relationship. Under the Family Law Act, there is a general requirement for a 2-year duration of the relationship, which is subject to some exceptions. This 2-year duration test is not the qualifying criteria for family provision matters. Difficulties can arise in modern relationships where partners are together but may live under separate roofs due to work commitments in other cities. And as you can see, it can be a complex question. We're now going to look at what I consider to be a very interesting case, Nelson and Brennan. Here, the male deceased was aged 57 when he died. He left his entire estate to his 2 children and the children of his 2 sisters. The plaintiff, that is the person bringing the claim, Anne Nelson, alleged she was the de facto spouse of the deceased at the time of his death. It was noted that the deceased made his will at a time when the plaintiff and the deceased were not together. The children disputed that the plaintiff, Anne Nelson, was in a de facto relationship with their father at the time of his death. They did admit that the plaintiff was a member of the same household. Ultimately, the court held that there was a de facto relationship despite the following facts. 1, the deceased did not reveal to all of his friends and relatives that he was living in a de facto relationship with the plaintiff. 2, the plaintiff specifically admitted that she had an obligation to inform Centrelink that she was in a de facto relationship, and she did not do this because she did not want to jeopardise receiving her pension. 3, the plaintiff was aware of an obligation to inform the Housing Commission whether there was anyone else living with her in the Housing Commission accommodation, and she did not do so. It was held, and this is a quote from the judgment, the foregoing conduct on the part of the plaintiff reflects no credit upon her. Nevertheless, it is not determinative of whether or not she and the deceased were living in a de facto relationship. I take this opportunity to echo Catherine's earlier comments that you can't rely on what happened in a friend or family member's case when it comes to your own circumstances. You can't rely on what you find out by Googling the law either. Any application of the law depends quite particularly on the circumstances of your case. In conclusion, it's important to know you cannot prevent a family provision claim, but you can be made aware of who can make a claim and why. It's also important to be aware that just because someone is eligible does not mean that they will be successful in bringing a claim, and what must be proven in order to obtain an order for provision is a very different story, the subject of another webinar. Thank you.
Thanks, Anthea. Now, I'd like to turn to Tim now to present his segment of the webinar today.
Okay, thanks, Catherine. Thanks, Anthea. Today, I'll be giving a bit of a commentary on what we have seen in this office in the sphere of wills and COVID-19. And I'll also move on to tie things in, I suppose, with what Catherine and Anthea have been talking about and how wills can be used as a sort of asset protection measure in the context of family provision and family law. So wills really tie those issues together. Now,
Sorry.
okay, I'll move on. Now, just a comment on the pandemic and how that's affected the sphere of wills. Now, really, it's had only minimal impact on the hard law surrounding wills and how they're made. There has been one important change, though, and I probably call it the sole change that's really happened, is that there's been a bit of a relaxing of the formalities as far as signing your wills. Now, so the New South Wales government introduced the Electronic Transactions Amendment Regulation, the full title on your screen there. Now, that introduced the remote witnessing of wills. So parties, for the time being and for now, can witness their wills remotely, so via a video link where the will maker signs in one place and the witnesses watch them do so and then sign on a separate copy. So it's just a pretty drastic measure considering how the laws of wills have really operated up to now. I should mention, however, that it is still a temporary measure, and I do expect that it might be repealed. But right now, it's been quite convenient for some of our clients. So that's the major legal change that we've seen. However, as we say here, that the social and the health impacts of the pandemic have been a lot more vast. So in the last year, I'd say we've seen a lot more people recognising the need to create their wills, get them in order. Perhaps people are considering their own mortality a bit. Many clients are also considering their powers of attorney and their appointments of enduring guardian. So these documents that they have to have in place while they're still alive in case they became unwell or could no longer make decisions for themselves. And along that line, we also seeing clients considering a healthcare directive, also called a living will, which is to do with specific wishes they might have in the event that they become very unwell. So we have seen a lot more of people considering that at the moment. So some general comments here about when you should think about your will. Generally, as a rule of thumb in this office, we would recommend to our clients that they review their wills every 5 years or so. But of course, there are other times where you have to think about them immediately. So a common situation is if our clients have children from different relationships, that can be quite a complex situation and definitely something that has to be dealt with quickly. Another point to make is that if you get married, that will revoke any will that you already have. So once you get married, you have to think about your will again. A common misperception is that separation will also cancel or revoke your will. That is not the case. So if you separate, you must review your will immediately. Now, also interesting to note that divorce does not automatically revoke a will. Now, it does invalidate the gift to your ex-spouse, but the rest of the will continue to operate. So the lesson is just to keep an eye on your will, particularly if any changes in your family unit happen. Okay, now tying this in with some of Anthony's discussion about family provision claims. Now, a question we often get from clients is how can they draft their will in a way that they can protect it from family provision claims? And like Anthony said, there's really no way just to knock out any potential claim on your estate. If somebody is an eligible person, they can make a claim. Of course, they'll have to prove many other things to be successful in that claim, but you can't just, there's no panacea. Now, there is a common misperception that you can make a small token gift in your will and that will stop somebody from, or can kind of negate any claim that they might have in your estate. Now, this is certainly not true. I guess in some cases they can be effective moderately, but by the same token, in other cases, they can be totally counterproductive. So again, on that theme, every case is different and requires an assessment of the circumstances and its own strategy. Okay, so moving on to another issue, I might have a little commentary here on discretionary trusts. That includes discretionary testamentary trusts and how they can be used for asset protection and those types of things. Now, this ties in with Catherine's earlier discussion on how the family courts, for example, divide property when couples separate. It's a very complex area of law. The family court can treat inheritances in a variety of ways. So clients are always going to need their own advice, which is tailored to their circumstances. But discretionary trusts they're often used for financial reasons like income splitting and reducing a tax burden that are associated with assets, and then they also, I suppose, they have an asset protection function as well. With the effectiveness of that can vary. So the most common example of a discretionary trust is usually a family trust where you have mum or dad or both controlling the assets of the trust, which are essentially held on behalf of their wider family. Now, the case on the screen here is a High Court case in the matter of Kennan and Spry. Now, this was a case where the husband sought to exclude the assets of his family trust from the asset pool when he and his wife separated. Now, the court quite easily saw through the facade of this family trust, and they did bring the assets of the trust into the asset pool. Now, the main reason being that the husband remained essentially in total control of the trust and the assets. So in this case, the discretionary trust was not a very effective asset protection measure. Now, if I move on. Now, by contrast, this next case we'll discuss, there's a recent case of the matter of Bernard and Bernard. Now, this considered a testamentary discretionary trust. Now, that's a type of discretionary trust which is created in somebody's will. A common example might be where the will maker, upon their death, creates separate trusts for each of their children almost like separate family trusts created for each of their children. Now, in this case, the husband was a beneficiary of a testamentary trust created by his father, but importantly, he was not in control of the assets. Rather, his deceased father, who made the will, appointed his sister as the trustee of his trust. So when the husband and his wife separated, in this case, the court decided that it could not access the assets of the trust and divide those up. So this is an example of how your will can be used as another strategy for asset protection. And I guess it's particularly relevant, I suppose, when clients of ours might ask us how they might be able to protect their child's inheritance if in the case of relationship breakdown. All right, now there are some other strategies that people might use to protect the inheritances they want to make in their will, or the gifts they want to make, I'm sorry. Now they are varying degrees of effectiveness, but these are some of the strategies that people might implement. Now, some people might dispose of assets before they die, they move assets to another jurisdiction, or create joint tenancies. And also there's some people might move assets into superannuation, because superannuation, of course, is separate from the assets of an estate. Now, of course, those rules in regards to super are quite strict and probably beyond the scope of today's conversation. And again, I say you always need legal advice on each of these strategies. It all depends on your own circumstances. Okay, and just to bring all those together, I suppose the key points that I've discussed today in regards to wills and how they link up with these other issues Catherine and Anthony have been talking about. So temporary measures were introduced to permit wills to be signed and witnessed electronically. You must keep an eye on your will, and particularly so if there's any changes in your family unit, separation, divorce, or hopefully marriage. And otherwise, as a general rule of thumb, like I say, we would always advise that you review your will at least every 5 years. Okay.
Thank you, Tim. Now, I think it's time to check out the questions, and I can see that there's a few questions here. Let me just have a look, and okay, there's very different questions. So let's just having a look at these here. So one person has said, what's the position if you separate 5 years ago and you're only doing the settlement now? Does it go on today's figure and what the situation was 5 years ago? That's a good question. And in fact, what you would do is when you put your submissions to the mediator, if you go to mediation or if you go to a court, you put a record to the court of the assets at the date that the parties began to cohabit, the assets at the date of separation, and also the current assets. And the law is that the court will look at what the current assets are. But that's why it is important to try to resolve things as soon as possible so people can get on with their own lives. So it is the assets as at now. Okay. Right, and somebody's asked a question here, again, another family law question. I'm just scrolling through these. Yeah, where yes, the family court has the power under the Family Law Act to split superannuation, and they can do it two ways. And I see. And it's quite a complicated question. Superannuation is very complicated, and I think this question may have come from an accountant. That's why we usually recommend that the parties get advice, particularly if it's a self-managed super. And also there are various specialists who can advise about how much is about how the superannuation works. Sometimes people do draft orders which give a percentage, other times they give a specific amount, and it's important that people draft the orders properly. So one of the issues that I've seen is solicitors who don't practice in the area drafting these superannuation orders, and I think the person who's asked this question has done this, and so they're actually preparing orders that are very difficult to carry out. So again, a reason why a person who's going through a family law settlement ought to get advice from an accredited specialist. Okay, there's a further question. So I'm just scrolling down. Is a parent an eligible applicant? So I think that's for you, Anthea.
I think
is
that
right?
question's for me. A parent is not automatically an eligible person under the Act, but they may fall into a different category of eligible persons, such as a member of the same household. But what makes things difficult for parents to claim is that another aspect that the court considers that I didn't talk about today, but is that you need to show dependence on the deceased person. And that can be very difficult, particularly where the parent is the one providing the financial resources. But it really depends, in the case of a parent, whether they're, the long and the short is they're not automatically eligible. They may be eligible. It will depend on the circumstances of the case.
Thank you, Anthea. And then we've got a question here for Tim, which is about Tim's example of a family trust being in the control of the sister instead of the husband. Can you see this, Tim? Yep.
And the question is, are you suggesting that if someone unrelated to the family unit to be the trustee, you can avoid assets in that particular trust being counted towards the joint asset pool? Well, no, there's no blanket rule. It's certainly not black and white. In that particular case, the court found that, yes, those assets were to be excluded because they are outside their control. I should say it's one of a number of factors they considered. So the main point is there are ways, depending on each particular case, there are strategies that can be implemented to protect assets. It certainly requires a review of all the particular circumstances of that case.
Thanks, Tim. And I think we've got another one for you here about that Bernard case.
Yeah, it is going to the same point. So, Tim, do you think it was significant that in the Bernard versus Bernard that the beneficiary was not a trustee and his sister was? Yes, that's much the same question. That was one of the key factors that the court did consider in determining that the assets of that trust should not fall into the asset pool being split. And it was also that the sister, who was the trustee, did owe obligations to other beneficiaries, and the husband could not himself procure a distribution of the trust, or he could not himself force the assets or anything to come into his control.
Thank you, Tim. And we've got a question here for Anthea. Anthea?
It's a great question, and it's a very common question, and it is, do the costs of a will challenge come out of the estate for both parties? And the answer is they may or they may not. It really depends. It's very common that the person, the executor, the person who defends the will be allowed their costs out of the estate, but it's not necessarily automatic. And there have been a few judgments recently where the court has been very critical of practitioners taking their costs out, assuming that those costs will come from the estate. The situation for a plaintiff, that is the person bringing a claim, is very different. They usually have to meet their costs on an ongoing basis. And then if they are successful, whether it be via a court order or via an agreement, then they will get some portion of their fees out of the estate. But the reality is it really depends on many different circumstances as to whether both parties will get their full cost from the estate or not.
Thank you, Anthea. Just on cost, it's quite an interesting question. People always ask how much do things cost and how long will it take? In family law, the rule is usually each party pays their own costs. So it's quite different to civil litigation and other ones where the other party might pay. So that's quite important. And the other thing to remember is that there's costs involved in any court action. There's filing fees, and there's also the costs of getting legal advice. I just wanted to mention something just on that. sometimes people are hesitant and want to do it yourself type legal advice. They go onto the internet, they get wills from the newsagent, for example, those sorts of things. And we would caution you very strongly against that, because, for example, these days, if you want to have a baby and have an obstetrician, you'll be paying thousands of dollars for that. If you want to have a funeral and you can't, as far as I'm aware, have a do-it-yourself funeral, you'll be up for over $5,000. So in the scheme of things, it makes good sense to spend some money on getting your will properly drafted so that it can do what it is that you want to do after your death, and also that you get proper advice about family law. It's fine to have discussions about how to split up assets, but it's really important that you document properly how you're splitting your assets up, because otherwise it may well be questioned later on and you mightn't be able to enforce it. The other reason to get formal orders or a formal agreement is that you're able to get, for example, the benefit of stamp duty exemptions on transfers. So again, a really good reason to get legal advice from a lawyer in family law, in will drafting, or in family provision or estates, rather than trying to do it yourself. So let's see if there's any more questions that are rising. Some people have given some feedback, so thank you for that feedback. And one of the questions is, will it be available later on to be listened to? And yes, we are recording this. And so I believe it will be disseminated to those of you who've attended. So I think we're almost there if there's no further questions. So thank you very much for dialing into this webinar today. Hunt & Hunt are really pleased to be able to offer a series of webinars. We are a medium-sized national firm and we provide services over a number of areas: corporate, family law, employment, litigation, commercial transactions, property, environment, and also insolvency. And so we'd be very happy to help you if you've got any queries. So please get in touch with us. You can get in touch with us through our website, and that has links to practitioners on it. So wishing you all the very best for the rest of the day, and thanks again.
Thank you.